Samuel.
Good morning, my lords and ladies. I appear for the claimant with Adrian Berry and Admas Habitus Lassie, David Blundell, KC, Julius Smythe and Nicholas Chapman appear for the respondent.
Yes, I wonder if before we get into the substance, we can just contemplate the time estimate that's been given for the appeal. It's listed for 2 days. Is that likely?
I would have thought we could finish within 1.5.
All right.
I just want to check the court has the relevant bundles. There's a core bundle, there's a further unagreed bundle, and there's an authorities bundle. Unfortunately, there was a slight problem with the electronic numbering, as I understand it, and therefore tab 7 was replaced into tab 42. Unfortunately, that is the main provision with which the court is concerned, the British Nationality Act.
This is the authorities bundle
Yes.
we're talking about.
So if
tab 7, I've got the British Nationality Act.
yes, well, in the electronic version, that is now in tab 42 and numbered to enable direct access through the numbering provisions. But I expect that we can deal with it as we go along.
Yes, well, when you're making your submissions, if you can give electronic references that are different separately and indicate that they are different.
Yes, well, I'll give what I've done. There has actually been a replacement. I've actually put my tab 7 into tab 42 and given it the page. The court actually has a hard copy of that, or should have been given a hard copy of that.
So, well, I haven't.
You haven't. At the back of the bundle, have you got a tab 42?
I've got a tab 41.
Oh, okay, so the hard copies haven't reached you.
No.
Okay, well, I will use both.
Yes, good. And the unagreed bundle, which is quite small. What do you want us to do with that?
It's not desperately important.
Right.
To be quite frank.
Okay.
So I wouldn't worry about it too much. Now, my lords, there are 2 issues before this court. If the appellant is successful on either one of them, then he is a British citizen by virtue of birth. And those 2 issues are whether, for the purposes of the British Nationality Act 1981, on the date that he was born, his mother was A, subject, I emphasize the words, under the immigration laws to restrictions, and the second issue, if so, whether those restrictions were as to the period for which she was entitled to remain. The position of the respondent is that because the appellant's mother had not been granted indefinite leave to remain at the time that the appellant was born, she was not settled under the British Nationality Act. And you will no doubt have picked up from your reading that the Secretary of State did not construe the British Nationality Act in this way prior to 2 October 2000. From its inception in 1981, coming into force in 1983, until that date, 2 October 2000, the Secretary of State understood settled in section 1, subsection 1b of the British Nationality Act as including an EU national who was ordinarily resident in the UK and was exercising free movement rights when the child was born. Thus, for 17 years, British nationality was afforded to individuals born to EU nationals who were ordinarily resident here and were exercising free movement rights at the time of their child's birth. By regulations adopted in 2000, the Secretary of State purported, however, to narrow that definition of settled in the British Nationality Act and the Immigration Act by way of Regulation 8 of the 2000 regulations. And you find that in tab 8 of the authorities, tab you find that in the 2000 regulations adopted pursuant to powers under Section 2.2 of the European Communities Act, the Secretary of State purported to narrow the definition that she had previously applied of the British Nationality Act, Section 11B, by using a regulation, Regulation 8. And you see that she says, for the purposes of the 1971 Act and the British Nationality Act, the following are to be regarded as persons who are in the United Kingdom without being subject under the immigration laws to any restriction on the period on which, for which they may remain. That is the definition of settled, I will take you to at a certain point. Therefore, she set out here a set of categories who were to be considered settled. And in 8.2 provided that a qualified person or family member who is not mentioned in paragraph 1.1, i.e. even if they are exercising EU freedom of movement rights, is not, by virtue of his status as a qualified person or the family member of a qualified person, to be regarded for those purposes. So that was, in effect, a purported amendment, we say, or attempt to amend the meaning of settled in the British Nationality Act. Now, that was, of course, not permissible. You cannot alter primary legislation relating to British nationality by using a power in Section 2.2 of the European Communities Act. And the Secretary of State has now accepted that that is right. Regulation 8 of the 2008 regulations would be ultra vires insofar as it sought to narrow or change any definition of settled as intended and provided in the British Nationality Act. So the Secretary of State's position altered in the course of these proceedings, and its position before this court is that in fact the 2000 regulations in no way affected the meaning of settled in the British Nationality Act. Rather, it simply involved a statement of the law as it had always been way back to 1981. So the Secretary of State's submission is that from its inception in 1981, the categorization in Regulation 8, I will explain a bit further, there's a slight nuance to that, but essentially that categorization is the correct categorization that Parliament had intended in the definition of settled in the British Nationality Act in 1981. And the reason given for this is apparently that the Secretary of State who had promulgated this legislation in 1981 had misunderstood its meaning for 17 years. And when it suddenly understood what Parliament had intended in 1981, it clarified the position by adopting Regulation 8, simply to make it clear what the Act had always meant. So the Secretary of State's position is that in enacting the British Nationality Act in 1981, Parliament had always intended settled, insofar as it related to an EU national, to mean nothing less than permanent right to remain pursuant to EU law. Not domestic law, EU law. And that is its position before this court. Now, leaving aside, my lords, the oddity of the Minister and Department that promulgated the relevant legislation misunderstanding what Parliament had intended, and doing so for the first 17 years of its application, there is another essential and overarching point. And this point, we submit, the court must hold at the centre of its analysis when interpreting the legislation. The point is that British nationality is solely a matter of domestic law. It is not, and Parliament never, we submit, intended it to be a question of Thus, whilst the respondent, both before the High Court and before this court, has sought to characterise this case as involving an analysis of the nature and extent of the mother's EU law rights, we say that approach is wrong. British nationality is solely a question of national law. EU rights are relevant only to the extent that they may assist the court to understand what Parliament intended when it enacted Section 11B of the British Nationality Act. And in our submission, Parliament never intended Section 11B of the British Nationality Act or the Immigration Act to make EU law rights determinative of the concept of settled in domestic law. Put another way, Parliament did not intend settled, insofar as it related to EU nationals exercising free movement rights, to be defined by reference to whatever the position was at the relevant moment under EU law regarding residence rights. Had Parliament intended settled when applied to EU nationals to require an individual to establish an EU right to permanent residence rather than an absence of restrictions under the immigration laws, as is provided for, Parliament would have made that clear. And I just want to refer you to Benyon, which is in Authorities Bundle, tab 35. And I just want to refer you to 14, make it clear that this court must essentially look at what Parliament intended in 1981. 14.2, when construing an enactment applies to a new state of affairs, the court will pay particular attention to the wording of the enactment, its purpose, and whether the new state of affairs is of a similar nature to that in respect of the enactment past. And then on the following page, a reference to the Royal College of Nursing case. In interpreting an act of Parliament, it is proper and indeed necessary to have regards to the state of affairs existing and known by Parliament to be existing at the time. And that is what I rely on in my submissions that will follow. We have to look at what Parliament knew at the time it enacted the 1981, and it is a fair presumption, as provided there, that Parliament's policy or intention is directed to that state of affairs. So we have to look at what Parliament knew when it enacted the British Nationality Act in 1981. Now, we say that both the context and the concept of British nationality, the British Nationality Act, show that it was not Parliament's intention that settled should be defined by reference to an EU right of residence. Indeed, far from doing that, Parliament in fact removed or exempted EU nationals exercising free movement rights from the application of the Immigration Act and immigration rules, i.e. the requirements of leave to enter and remain. And Parliament did that without stating that that exemption could not be relied on for the purposes of establishing settlement. Now, the reason that that is relevant is because other categories, such as the armed forces or diplomats, were also exempted from the requirements of leave to enter and remain in the Immigration Act. And in relation to some of those cases, Parliament made express provision that the exemption could not be relied upon as a basis for establishing settlement, i.e. it identified where exemption in the Immigration Act could not be used to establish settlement. And in our submission, therefore, the Secretary of State's interpretation of the British Nationality Act from its enactment to 2000 was the correct interpretation. That is, EU citizens were exempted from the application of the Immigration Act, and therefore, where they were able to show that they were ordinarily resident and they were exercising free movement rights, they were not subject to restrictions under the immigration laws as to the period for which they could remain. And it followed that they were entitled to rely on that exemption as the basis for showing that they were settled. Turning then to the relevant statutory provisions, you find these at section 1 and 50 of the British Nationality Act. It's your tab 7, my tab 42, and it is at page 659. Electronic page 659. So the key provision, if you've got it, is a person born in the United Kingdom after commencement shall be a British citizen if at the time of his birth his father or mother is B, settled in the United Kingdom. And we find the definition in section 50, which is at page 716 of the electronic, 715 of the electronic bundle. You'll see settled at the bottom of the page. Settled shall be construed in accordance with subsections 2 and 4. And then you have 2, subject to subsection 3, references in this act to a person being settled in the United Kingdom or in a dependent territory are references to his being ordinarily resident in the United Kingdom or, as the case may be, in that territory without being subject under the immigration laws to any restriction on the period of time for which he may remain. The key sentence for the purposes of this hearing. And then we have the exemptions in 53. Subject to subsection 4, a person is not to be regarded for the purposes of that as having been settled in the United Kingdom at the time when he was entitled to an exemption under 834BC of the Immigration Act, or unless the order under section 8 of that act conferring the exemption in question provides otherwise, to an exemption under the said section 8.2 or any corresponding exemption under the former immigration laws, or as having been settled in a dependent territory at any time when he was under the immigration laws entitled to an exemption corresponding to any such exemption, as is mentioned in paragraph A. So extending that to dependent territories.
Sorry, which paragraph are you reading?
53B, 53 subsection B.
Thank you.
That paragraph being, for the purposes of this paragraph, read as if the words unless and otherwise were omitted. So extending that to the dependent territories, that position. And
you emphasise that. Are we to take anything from the emphasis that you keep giving to dependent territories?
yes, because I'm going to refer to it when I deal with the argument about the definition of immigration laws.
All right.
So our point in relation to this section, which I will develop further, is that EU citizens were exempted from the Immigration Act 1971 by Section 7 of the Immigration Act 1988, and that's at Authorities Bundle tab 8. However, when making that exemption, neither Section 50, subsection 3, nor any other section, the Immigration Act or the 1988 Act, provided that EU citizens were not to be regarded as settled for the purposes of the British Nationality Act or otherwise by virtue of that exemption. You would have expected to see an equivalent provision. And had that been the intention, we say that plainly would have been provided for by Parliament. Now, the judge dealt with this in paragraph 87 of his judgment, but unfortunately, his reasoning is based on a fundamental error. And I don't want to take you to that yet because I'm going to take it to you in a minute, but I just want to make the point, I will repeat it. he didn't appear to realise that it was Section 7 of the 1988 Act that took EU nationals exercising free movement rights outside of the immigration laws, Immigration Act 1971, and exempted them from the application of those immigration laws. Rather, in that paragraph, as I will take you to, he approached the matter on the erroneous basis that it was the 2000 regulations, which I refer to, the year 2000 regulations, adopted under the European Communities Act, that had had that effect. Returning then to the definition of settled. The first requirement...
Can I just be sure, because I don't want to miss any of your very important arguments, Ms. Simon. You are going to go back to paragraph 87.
Well, I hope that I have cross-referred back to it again. Yes, I have. So I am going to, yes, when I deal with that in more detail.
Yes.
Yes.
So,
it's
all right.
And I will, because I'm going to take you to those provisions also in the Immigration Act, Section 8, 1971 Immigration Act, to which Section 50, subsection 3 refers. Is that the whole? Yeah. That's tab 22. If you'd like to put the electronic numbered hard copy into your bundle of the British Nationality Act, we do have copies for you.
Well, we can take that at the short adjournment, I would think.
Could I mention in that regard, I'm looking at the electronic bundle, and the last page of that in my electronic bundle is page 657.
Well, then you haven't got the new electronic bundle. I assume it's a new electronic bundle, is it?
Yes, that should have been sent.
Yeah, you should have had the... So what's happened, I think, to make it work, unfortunately, the tab 8 needed to be put at the end, and you should have had a new electronic bundle. But we have hard copies of tab 8. In any event, this is the key piece of legislation, obviously, so you've got to have it.
Well, I think it's therefore necessary for your judges to make sure that we do have it.
Yes, well,
electronically.
It was sent to the court, so
That's no good to us now.
The clerk.
Yes, it was sent to the clerk. If there's an email address that it could be sent to now, I'd get that sent across immediately.
Yes, perhaps you could send it to the court associate and they can send it through to our respective addresses.
Of course, ma'am.
Thank you very much. Be very helpful. Thank you.
So I want to return now to the definition of settled.
Yes, thank you.
Now, the first requirement of settled, you will have noted, is that an individual is ordinarily resident. And it's not in dispute before you that the appellant's mother was, at the time of his birth, ordinarily resident in the United Kingdom. And the central authority for residence, or ordinary residence, is the case of Shah and Barnett, 1983, 2 Appeal Courts 309. Now, that is not in the bundle because the issue is not in dispute. But I would nonetheless submit that it's important that your lordships and ladyships are aware precisely what ordinary residence means. You'll find it cited in paragraph 2 of our skeleton before the High Court, which is in the core bundle, tab 12, page 121.
And what about the skeleton argument for this court? Is it in that one?
It's not in that one because
it's not an issue.
It's not an issue, but it's nonetheless important in your understanding of the overall meaning of what Parliament was doing here. Because what
if it was, why isn't it in the bundle? Probably my
failure in some regard to note that actually was a point that needed to be made in the skeleton.
Well, if it's not an issue, obviously, one can be forgiven, Mr. Moore, for saying it's not necessary. But if it is going to be important for us to understand, as you say, then it should be in either the authorities bundle or in your skeleton. So can that be addressed in terms of authority?
Well, we have copies of Shah.
All right.
As I say, it's not something that is in dispute. And I'm sorry that it wasn't specifically referred to.
Well, again, that can be handed up in due course, but what is it that you'll want us to take from that then?
I'm going to take
All right.
It's a very short point.
All right.
It's simply that the first limb of settled is ordinary residence.
Well, we
And
can see that from the...
Yes, but in order, your lords and ladyships may well be aware what ordinary residence means, but if you're not, the test is whether the applicant, and this is a quote, open quotes, the applicant has habitually and normally resided in the United Kingdom from choice and for a settled purpose. And that is Lord Scarman at page 349 of the Shark case.
And that's all you want us to take from
That's all
that?
I want you to take.
Right.
My submission in relation to it is that this is one of the elements that Parliament had in mind when defining settled in the British Nationality Act. So it doesn't depend on immigration status, and it may be something less than settled. But it is nonetheless an important threshold requirement in order to establish settled. And therefore Parliament knew, in defining it, that nobody who was not habitually and normally resident in the United Kingdom from choice and for a settled purpose could meet the settled test in section 52 of the British Nationality Act.
I've been handed more than Shah, I think. Oh no, I haven't, but I haven't been handed the front piece.
Maybe there's been a slight muddle with tab.
Thank you. Thank you. So I've now got 2 copies, if anyone's... Would you like one back, Miss
I'll take it back.
Thank you. Thank you very much. Thank you.
So turning then to the first issue before the court. At the time of the appellant's birth, was his mother subject to restrictions under the immigration laws? And I refer you, and then you'll see that from section 52 of the British Nationality Act. And
before you start on that, can I just clarify one thing? Do I understand that although it's now accepted that the Regulation 8 did not change the position legally, the Secretary of State is not reneging on the position it took prior to the 2nd of October?
What happened was the Secretary of State accepted that if his legal submission was correct, then he had applied the British Nationality Act wrongly for 17 years. And therefore those who had been granted British nationality during that period should not have been granted British nationality. Now the implications of that were such that primary legislation was subsequently tabled to deal with this 17-year mistake, to afford those individuals who had been granted British Nationality Act apparently wrongly British nationality retrospectively.
Right. So we are only concerned with the period after the 2nd of October, although we're interpreting the law prior to that.
Yes. Now our submission is that you should ignore that subsequent act in considering the inference that one may draw from the fact that from 17 years from promulgating the legislation it was applied in a particular way. We say
But if you're right, that act wasn't necessary.
That's right. That's right. But because of this case, there were very many people, including, for example, somebody who couldn't get settled status because she was born before the 2nd of October 2000. And therefore, and so she arrived in the country with her child, having always lived here, and she was told she couldn't come in. She said, but I was refused, I couldn't apply for settled status. Apologies for giving it. I couldn't apply for settled status because the passport office had told me that I was a British citizen. So there were, and that whole position was halted, so she didn't even have a passport, but she received a letter saying, sorry, because of this case, everything's on hold. And so they put this through to deal with many, many cases like that, and all the potential problems, including, for example, children having been given British nationality. So that's why they rushed the legislation through. But we say it's not relevant for your purposes because the correct position was the contrary to what Mr. Justice Eyre found, we say, in his judgment. The correct position was the position that the Secretary of State took when he promulgated the legislation for the 17 years following.
But it is the case that Parliament has acted on the basis of the interpretation of the 1981 Act, which is contrary to your submission.
Yes. Parliament has acted on the basis of the judge below, Mr. Justice Eyre's judgment. But we say it's not relevant to your analysis.
Which was the provision?
It corrected, the legislation is actually in tab 15.
The title would seem to be correct.
Regularization of past practice, yes. Now we say that was done, that didn't need to have been done, save for the fact that a judgment existed that made it necessary, essentially. And also, it wasn't just a judgment, it was also the argument that was being made by the Secretary of State. So what we heard in the first day of court before the High Court was that the consideration of all applications had been put on hold as a result of the case, including those that related to birth prior to 2 October 2000. Because, of course, as with this case, an application for citizenship can come way after the actual date of birth.
When was Mr. Justice Eyre's judgment promulgated?
Was it January 2023?
So January. So
January.
This legislation was within 6 months of that?
Yes.
Or it was in force from the 29th of June, yes? It says 29th of June to present. So I'm taking that that's when it was in force. Yeah.
And your lordships will appreciate that obviously this is it was also a complex time. It's also a complex time because of individuals falling between two stools as to whether they're British citizens or they should apply for settled status, etc. So there were added complexities. But in any event, it was something that needed to be sorted out, otherwise people can't have passports, people can't move, and people who have children of British nationals, are they British nationals or not, etc.
The order wasn't sealed until the 18th of May, though.
In this case?
Yes.
It may be. But it was not just the judgment. It was also because the Secretary of State was now arguing in front of a court that the 2000 regulations didn't actually change the legislation. And as soon as the Secretary of State accepted that it was not the regulations that had amended the British Nationality Act, it was simply a policy error that had been made for 17 years, then the Secretary of State had to adopt legislation to deal with that error that it said it had committed.
Yes, thank you.
And I assume, I don't know, but I assume that that issue was being considered within the Home Office during even the legal argument.
And Section 1, subsection 2 of the Regularisation of Past Practice Act says that subsection 1 is treated as always having had effect.
the interpretation at 50B is the interpretation that we say was always right. That's what Parliament intended by Section 11B of the British Nationality Act, and that's how it was applied by the Secretary of State and Department that had promulgated the very same legislation. And indeed,
forgive me though, but if Parliament has now deemed that to be a remedial period by statutory provision, mustn't we give effect to that? That is a parliamentary decision that a remedy was required because of the meaning of the previous act. How can we ignore that parliamentary intent?
in our submission, this court should look at the question of what was intended when Parliament enacted the British Nationality Act itself.
But has Parliament not determined that by its subsequent act?
Our submission is no, not for the purposes of this court.
Do we need to look at some law on that? Can Parliament determine what a previous act meant?
Yes, well, the premise for the legislation was that this was a practice, not actually the application of the law, and we dispute that before.
But isn't the premise that the practice was to ignore, to disregard the restriction? So it is the premise of the act is that there was a restriction, and it was in practice disregarded.
Yes, well, my lord, that's what the legislation says, but the reality is that the British Nationality Act, you cannot retrospectively amend what was intended to be meant by Parliament at the time of the legislation. But we will, if that is a matter that particularly concerns you, it's not, we will do some further.
It's not a point being taken against
It's not being taken.
No. It just seems, I'm just concerned that that we're being invited, as I understand it, to reach a conclusion which is contrary to the premise of an Act of Parliament, which seems to me to be potentially a difficult proposition.
Well, what Parliament appears to have done here is to have interjected itself, if you like, in existing litigation. And that does itself raise...
That's maybe the motivation for it, but I don't think that's what Parliament is doing.
No, it's not specifically about this litigation, but it interjects to affect prior...
What it's saying is because a previous Act of Parliament had a particular effect, but was disregarded by the executive, Parliament will now correct that position, so that parties who were misled as to its effect do not suffer. That's what it's doing.
That is effectively what it's doing. And in our submission, this court should simply analyse the British Nationality Act as it applies in this litigation.
Appreciate that.
But I take your point, my lord.
So does it come to this then, Miss Simon, following on from what my lord has asked, that this court is determining this application only? Because as my lord says, there is now legislation which it would be difficult for this court to undermine, other than in relation to the facts of a case that were determined before the legislation
Well,
was
what we've been
enforced.
asking was in relation to the period after the 1st of October 2000. Because the remedial period is only up to the 1st of October 2000.
And can I just be clear, you're not saying that this was the result of the judgment in this case, this legislation?
It appears to me that it is a result of two things. One, if the judgment had been in our favour before Mr. Justice Eyre, then this would not have been necessary, because the position would have been that as between 1983 and 2020, those born to individuals with ordinary residence and exercising free movement rights would be British. And therefore it would have dealt with that 17 years where those British citizens were made British citizens, that would have been correct.
The point is that your client was born after the remedial period. This Act is irrelevant to your client's case.
Yes.
But it was needed because the consequences of the judge's decision would have also affected parties born in the remedial period.
Not in the... no, it was needed, well, yes, in the remedial period, from 83 to 2000, yes. Yes. And that was because of a concession by the Secretary of State, because the prior position of the Secretary of State was that the law had essentially been changed by the 2000 regulations. And the Secretary of State accepted that those regulations would have been ultra vires if they had had that effect. And therefore the position was taken that the 2000 regulations did not amend the definition of settled. Rather, settled had always meant what the 2000 regulations say.
So accepting, as my lord has said, that the appellant doesn't come within these provisions simply because he was born after October 2000, what weight do you say this court should give to this piece of legislation?
We say no relevance or weight should be given to this for the appellant's purposes, and that what the court has to determine for his application is whether the 1981 Act, Section 11B and Section 50, whether in that Act Parliament intended that his mother, as an ordinarily resident French citizen in the UK, could claim to be settled by virtue of the fact that she was exercising her free movement rights, as had been in the case in the remedial period. So, turning then to the first issue before the court is whether the immigration laws referred to in Section 52 of the British Nationality Act relate to or refer to EU laws, as the Secretary of State...
Terribly sorry, Miss Simon. So, slowest ship in the convoy and all the rest of it. So, you've taken us to this legislation effectively to say dismiss it from your mind,
Yes.
regardless of subsection 2. That provision inserted by subsection 1 is treated as always having had effect.
Yeah, our position is that you must determine this application by reference.
I know you keep saying
Yes.
that, but so what would you say about subsection 2?
We say essentially that subsection 2 does not have the effect of amending the meaning of the Act as intended by Parliament in the British Nationality Act. It provides a remedial provision, but it doesn't actually have the effect of amending the definition of settled.
Very much. And of course, this was not before the judge below.
No.
Yeah. Thank you.
So, turning then to immigration laws and what Parliament intended when it enacted Section 50, subsection 2. If we go to the British Nationality Act, we have 43. Sorry, 42, or it's your, go back to
7, tab 7.
page 716 of the electronic. So 52 is subject under the immigration laws. And then if you look to the prior page, 715, you see the definition of immigration laws.
Can you give us the paper bundle?
The paper bundle should be tab 7, and it's at the back.
It's not paginated within.
No, that's why the new set is paginated. It's quite a way through. It's in the interpretation section, section 50.
And which subsection are you looking at?
I'm looking at subsection 50. So I was looking first at 52, which we've already been to, 50 subsection 2.
Yeah.
And that refers to immigration laws. And then on the prior page, you see immigration laws defined.
Yep.
Yep. So it provides, in relation to the United Kingdom, means the Immigration Act and any law for purposes similar to that act, which is for the time being or has been at any time in force in any part of the United Kingdom. And then B, in relation to a dependent territory, means any law for purposes similar to the Immigration Act, which for the time being or has at any time been in force in that territory. And then you see the islands are the Channel Islands and the Isle of Man. And the United Kingdom on the following page is defined as Great Britain, Northern Ireland and the islands taken together. My lords, I realise, can I just take you back, because by being diverted into the remedial act, I wanted to give you, before opening on these points, the references to where we deal with these arguments that I'm going to set out now in our skeleton.
Thank you.
So for your note, we deal with these points at paragraphs 48 to 51 of our skeleton, which is at core bundle 4, page 40, core bundle, tab 4, page 40, and at our skeleton before the High Court at paragraphs 31 to 37, which is core bundle, tab 12, pages 129 to 131. Now,
is there a difference between the two?
there might be sort of further development in the one in the High Court. You might just find a little bit more development. I think it's slightly more crunched in the Court of Appeal.
Is it orthodox to have this process of having two skeleton arguments without combining all of your points in the skeleton argument before the Court of Appeal?
Well, what is orthodox is to put all the skeletons in a bundle. My lords and ladies do not need to read High Court skeleton if you don't want to. It's just that.
Well, if there's a difference, we should, but
there
it's
isn't
a meaningful
a significant
difference.
difference. Is we have to reduce the authorities in front of the Court of Appeal. We have to reduce our points in front of the Court of Appeal quite rightly. Sometimes.
Well, that's why it's not really permissible by the back door to extend the number of pages of skeleton argument, is it, by saying, well, refer to the High Court?
Well, it's in the core bundle. I'm not
Right.
asking you.
So your skeleton argument references are, again, please, Court of Appeal skeleton argument 48 to 51.
48 to 51. 1, which is Core Bundle tab 4, page 40. And I won't give you the High Court references.
Well, if they're relevant, do.
All right, yeah. Well, entirely up to you, not essential. Core Bundle tab 12, pages 129 to 131, paragraphs 31 to 37.
Thank you.
Now, the judge held that the words "for purposes similar to" in the definition of immigration laws in section 50 of the British Nationality Act included regulations adopted pursuant to section 2.2 of the European Communities Act 1972. That is the 1995 order and the 2000 regulations. And you find that in 49 to 84 of his judgment, which is at Core Bundle tab 8. Page 79. And if you start at 84, which is at page 87, you'll see that the judge concludes, it follows that the 2000 regulations were immigration laws for the purposes of the relevant provisions of the British Nationality Act.
Well, the crux really is captured, isn't it, in 82 and 83?
Yes. And then, thus he concluded that the entitlement to reside without leave to remain was a restriction under the immigration laws. And you find that at paragraph 49 of the judgment. On page 79, he asks himself the question in the last line, was the requirement that to be entitled to reside without leave to remain, M had to continue to be a qualified person, a restriction, i.e. the entitlement to reside as a result of being a qualified person, was that a restriction under UK immigration laws. So in short, he found that a right, as conferred by EU law, should be read as a restriction under UK immigration laws. And we say that in so finding he was wrong. We make 7 points. First, we say that for purposes similar in section 50 is intended to cover relevant analogous legislation applicable in the islands. And this is necessary because the United Kingdom, as defined in section 50, includes the islands, the Channel Islands and the Isle of Man. Accordingly, it was necessary for the legislature to include any law for purposes similar to the Immigration Act. And of course, Crown dependencies, etc., may make further provision in their own law, although certainly in the Channel Islands, if they stray too far from the UK law, they risk being expelled from the common travel area. So the modifications of the 71 Act are slight. Now that is supported, we say, by the fact that the same wording is used in relation to dependent territories, where the Immigration Act or similar laws may apply. In that regard, Her Majesty may, under section 36 of the Immigration Act 71, extend that act in whole or in part, but again, the dependent territories may adopt equivalent provisions themselves. And I will show you the Stevens case later, which is at Authorities Bundle tab 36, where the British Nationality Act was extended to overseas territories for the purposes of determining British overseas territories' nationality, and thus the Immigration Act equivalent in Bermuda would be what is referred to there as for purposes similar. So you find in section 33 of the 1971 Immigration Act the same terminology. And that's at tab 4 of the Authorities Bundle, page 27. It's page 27. You see the definition of immigration laws. Immigration laws means this act and any law for purposes similar to this act, which is for the time being or has been in force in any part of the United Kingdom. And again, the definition of United Kingdom further down. But we have the islands. Sorry, the islands means the Channel Islands and the Isle of Man, and the United Kingdom and islands means the United Kingdom and islands taken together. That's just below. And while we don't have it before you, just for your notes, Section 36 empowers Her Majesty by order in council to extend all or parts of the legislation, this legislation, to dependent territories in the islands. So under the British Nationality Act and the Immigration Act of 71, provision
Why have you
made,
referred us to section 36 that isn't in
just
the
to
bundle?
tell you that there is a power also to extend this.
Is it relevant to this case?
It's only to the extent that insofar as the Secretary of State can also extend this legislation, that may also be indicative of the fact that it's for the purposes. But the Crown dependencies also have their right to legislate.
Maybe indicative of what, sorry?
The Crown dependencies have...
No, before you said that, it may be indicative of...
It may be indicative of the fact that in referring to for purposes similar to, Parliament was referring to for purposes similar to, i.e. legislation that applies slightly differently, but in relation to Crown dependencies in the islands. So it's not the actual 1971 Act, it is another Act extended and applied in the islands or in the Crown dependencies for purposes similar to the 1971 Act. So under both the British Nationality Act and the Immigration Act, provision is made to ensure that immigration laws for similar purposes to the 71 Act are covered. Now, we consider that, a secondary point, we do consider that in referring, we do submit, in referring to the 1971 Act or legislation for similar purposes, that would include legislation adopted pursuant to that Act. For example, the immigration rules under Section 3.2 of the 1971 Act, SI's Order in Council, etc. And we note that the Interpretation Act certainly considers under Section 23.2 that where in the context of an Act it's made clear that a reference to an enactment includes subordinate legislation. And that makes sense because subordinate legislation, for example, includes time limits. And we have an example of such an order that we can hand up to the court.
Lot of handing up going on, Miss Simon.
Well, I don't need to hand it up. It's an obvious point, really, that the 1971 Act we submit includes subordinate legislation adopted under it. And such a legislation may, for example, provide time limits.
Well, why don't you hold on to things
Yes,
that might not be necessary unless Mr.
I don't want to...
Landau takes the point.
Now, the second submission we make is that Parliament was not referring to laws that derive from the European Union, whether directly pursuant to treaty rights or by way of regulations, which of course were directly effective and could be relied on directly in the UK, or through legislation implementing such rights and obligations. Thus, in our submission, Parliament did not contrary to what Mr. Justice Eyre found, intend to include within the definition of laws for similar purposes the implementation of EU obligations or the affording of EU rights through sections 2.1 and 2.2 of the European Communities Act. Indeed, in our submission, it would have been astonishing for Parliament to have intended to confer on the Secretary of State a power to enact legislation by order under the European Communities Act, which would potentially be determinative of British nationality. And had Parliament intended that, it would certainly, we submit, have expressly provided to that effect. Indeed, we can go further than that. If Parliament had intended, in referring to immigration laws or laws for similar purposes, to include EU rights and obligations, then that would have allowed British nationality potentially to be determined by reference to directly effective rights and obligations, i.e. treaty articles and regulations, which require no implementing legislation at all, as is clear from section 2.1 of the European Communities Act. And we note, of course, that there is no EU right, and never has been, to nationality of another member state. If the judge was right, then by section 50 of the British Nationality Act and section 33 of the Immigration Act, in referring to immigration laws, Parliament would have been including within that definition the 1968 Regulation on Freedom of Movement of Workers, or indeed the relevant treaty articles, which through section 2.1 were directly applicable in the UK from accession. And there is no indication that that was the intention. It is submitted that Parliament did not and would not have done that, or put another way, had it intended to do so, it would have provided for it expressly in the definition of immigration laws in section 50 of the British Nationality Act or section 33 of the Immigration Act. A third point is that the language, the purpose of law relating to EU free movement rights the purpose of law relating to EU free movement rights, which were enforceable through section 2.1 of the European Communities Act, i.e. directly, or through secondary legislation adopted under section 2.2, cannot be said to be for purposes similar to the Immigration Act and the Immigration Act 1971. And if I can take you to tab 5 of the authorities bundle, you'll find there the European Communities Act. So we are essentially saying here that the purposes of granting rights and obligations to the European Communities Act are in no sense purposes similar to the Immigration Act.
I'm very sorry, Miss Simon. Which tab again?
Authorities bundle tab
5, thank you.
Now, you'll see, I'm sure you're familiar with this, although of course it's now rather out of date, or extinct I should say. But nonetheless, section 2.1 of course provides that all rights and obligations deriving from the treaty or from directly effective regulations can be relied on directly by individuals in the United Kingdom. And subsection 2 gives Secretary of State, the designated minister, the power by order to implement community rights and obligations, enabling, and if I could emphasize in 2A, enabling any rights enjoyed or to be enjoyed by the United Kingdom under or by virtue of the treaty to be exercised. So the purpose is different. The purpose of the European Community Act is to give effect to rights and to remove restrictions. And these laws, these regulations that were enacted pursuant to section 2.2 were to give effect to rights and obligations, i.e. the abolition of restrictions subject to certain specific limitations. And we can see that in the 1995 order, which you find at tab 9. I apologise, my lady, but I would have liked the explanatory note to be in there, so I am going to hand that up to you. Is it already in there? Well,
It's page 56.
it's my
isn't it?
fault because it's actually in there, so I didn't need to have it copied. So here we see the explanatory note. On 20 July 1994, Section 7 comes into force. Now, Section 7.1, which I will take you to, is the primary legislation that exempts EU nationals exercising free movement rights from immigration, the Immigration Act. It provides that a person does not require leave to enter or remain in the United Kingdom in any case which is entitled to do so by virtue of an enforceable community right under Section 2.2. This order makes provisions for such persons by implementing the relevant community obligations which are set out below. These obligations apply to nationals of states which are parties to the European Economic Area, which came into force on 1 January 1994. Those states are the 12 states. And then the order provides that an EEA national and a family member of such a person may enter the United Kingdom on production of a valid EEA identity card. Family members who are not EEA nationals who are seeking to install themselves in the United Kingdom require a family permit. Those EEA nationals exercising community rights and their family members are entitled to reside in the United Kingdom and, subject to certain exceptions, to be issued with a residence permit. And the order also provides for EEA nationals and family members to be excluded and removed from the United Kingdom on public policy grounds only. Those who cease to exercise community rights may be removed. And then we have the community rights that are implemented, set out in a list below. And if we then go to Regulation 3, you'll see that it implements the right. EEA nationals shall be admitted to the United Kingdom if he produces a valid ID card. Family members shall be admitted. And a third country family member must also, if he's a visa national or person, a family permit, an EEA family permit. And then Regulation 4, a qualified person shall be entitled to reside in the United Kingdom without requirement for leave to remain for as long as he remains a qualified person. A family member of a qualified person shall be entitled to reside in the United Kingdom without requirement for as long as he remains a family member. A qualified member may reside and pursue economic activity in the United Kingdom, notwithstanding that his application for a residence permit or resident document has not been determined. So it's not dependent on a residence permit. And then 5, subject to 10 and 16, the Secretary of State shall grant a residence permit to a qualified person on application and production of a valid ID card. And that's an obligation, proof that he's a qualified person. And then if we go to Regulation 12,
Well, do you want Regulation 6? Because there's no dispute, is there, that the mother of the appellant is a qualified person because she comes within the category of worker?
yes, no dispute on that. And then if we go to 12, you'll see that subject to the following paragraphs, a resident permit shall be valid for at least 5 years, minimum 5 years. And then 12.4, no, it's not 12.4. I think it was. is Regulation 13, I will next. Subject to paragraph 2 and 3 in Article 16.1, a residence permit shall be renewed on application. So it's an indefinite right insofar as you are a qualified person. So you have a 5-year right to a residence permit and a right to automatic renewal. And there are limited circumstances set out in 13 relating to when you become unemployed, because of course becoming unemployed doesn't make you unqualified. You are still a qualified person if you are unemployed or seeking work. But 12 provides that, 13.2 provides that on the occasion of the first renewal of a worker's residence permit, the validity may be limited to 1 year if the worker has been involuntarily unemployed in the United Kingdom for more than 1 year.
And why are we looking at this particularly?
We're looking at all these because the point I'm making is that these are not for the purposes of the equivalent purposes of the 1971 Immigration Act. They are for the purposes of affording EU rights to individuals.
Yes. And that's all we're going there for.
Yes, it's to deal with Mr. Justice Eyre's finding that these regulations, adopted pursuant to Section 2.2, were, in his analysis, for the purposes, similar purposes to the 1971 Act, within the meaning of the British Nationality Act.
Yes, so you've taken us to the particular regulations that deal with residence and the right to a residence permit. And the reason you're doing that is to
just demonstrate that these regulations, in accordance with Section 2.2, are for the purposes of affording rights, not for the purposes of imposing restrictions.
Right.
What do we draw from the fact that they are headed immigration and are described as the Immigration European Economic Area Order 1994?
We submit that you don't draw anything when you interpret the words for the purposes. The fact that the same language is used, there's plenty of legislation referring to the words immigration. That doesn't mean that it's all covered by the definition in Section 50 of the British Nationality Act, or Section 30.
I don't think what you have addressed us on yet is what you say are the purposes of the 1971 Act.
Yes, well, I can answer that very simply. It's effectively to regulate leave to enter and remain under domestic law. And I will take you to Section 7 of the 1988 Act, which takes EU citizens out of the purview of that legislation. I exempt them from that legislation regulating entry, power to enter and remain. Well, I think I can skip over all of this because I've made my point, so I'm not going to take you to any more of these detailed provisions, save that perhaps it's worth noting at least that in Regulation 20, you will see that an EA national who is in the United Kingdom and the family member of such a person shall be treated as if you were a person who required leave to enter and remain in the United Kingdom under the 1971 Act on his ceasing to be a qualified person or the family member of a qualified person. So the purposes of that Act return. That Act is reapplies in relation to such individuals. But the purpose of Section 7 of the 1988 Act and this Act was to remove the control of the Immigration Act 1971 and legislation.
You say the purpose of the 1971 Act is to regulate leave to enter and remain under domestic law. But can it be put more broadly? The purpose of the 1971 Act is to control and regulate
Well, our primary submission is that the construction to be given to Section 50 is it is either the 1971 Act of Subordinate Legislation in the United Kingdom or legislation for similar purposes in the dependent territories or Crown dependencies, etc., Channel Islands. So that's what we say for the purposes means. Our secondary submission is that for the purposes does not include for legislation that is adopted for the purposes of conferring EU rights in circumstances where Parliament has expressly removed EU nationals exercising those rights from immigration control in the 1971 Act.
Can you take us to that provision?
Yes. Mark, I haven't dealt with that. The provision is at tab 8. Subsection 1, section 7.1, a person shall not, under the Principal Act, require leave to enter or remain in the United Kingdom in any case in which he is entitled to do so by virtue of an enforceable community right or any provision made under section 2.2 of the European Communities Act.
But does that answer my Lord's question that he posed to you?
Well, we say it's a separate purpose. If you do not accept my primary submission, which is that it is the Immigration Act, or for the purposes of similar in other territories, our secondary submission is that for the purposes under the European Communities Act is a different purpose. It is for the purposes of conferring rights, and the purpose of the 88 Act was to take EU nationals exercising free movement rights out of the control of the Immigration Act, right to enter and remain.
But only that specific part of the Immigration Act, right to enter and remain.
But that's the material part for our purposes.
So immigration control, you say, has got nothing in it, in terms of anything else that follows. Once the right to enter and remain in the country, we look at the regulations as 5 years and then maybe 1 year if there's been unemployment or if a student. But you say that we've got to look at it very strictly.
Yes. We say it's a separate purpose. It's not the purpose that Parliament intended when it enacted section 33.1 of the 1971 Act, which of course preceded us joining the EU. So it cannot have meant this. And then the 1981 Act, again, without specific reference to EU rights and obligations, we say the intention of Parliament was not to cover the conferral of rights or obligations by way of Section 2.2 of the European Communities Act. And that the definition of immigration laws in Section 33 of the 71 Act and Section 50 of the 1981 Act would have been amended by Parliament to make that clear, had that been intended.
As a matter of interest, subsection 2 of section 7, which is the class of persons who are nationals of member states who are not entitled to enter the United Kingdom, as mentioned in subsection 1.
Well, we have puzzled about that because it's difficult for us to envisage any person, save somebody who had been barred on the basis of public, social, other kind of reason, national security or such like, because of course there was a right to come and receive services, for example, tourism. So it was not permissible to prohibit EU nationals from entering the EU. That appears to be we're not quite sure what that is actually intended to refer to. Save that no, it's difficult, and we have puzzled over that because we can't see any class of person that could have been barred from entering the United Kingdom.
And does that exception undermine your argument at all? Or does it support it?
I can't, my lady, see a basis on which it undermines our argument.
Can you see a way in which it
Equally, I can't
supports it?
see how it supports our argument.
No, all right.
But I'll reflect further on your question.
All right.
Just going back to the purpose of the Immigration Act 1971, which we have at tab 4. The general principle starts at subsection 1, declaring the position of those with the right to abode, and that's picked up in section 2. Declaring who has the right of abode, if they're a British citizen, etc. Commonwealth citizen. None of that has anything to do with enforcing leave to enter or leave to remain, does it?
Well, a right of abode is a right to remain.
But subsection 2 particularises, as it were, the right of abode as different from those not having that right may live, work and settle. So there is a distinction drawn in the Act. So 1 subsection 1, right of abode, as my Lord has said, and then subsection 2, those not having that right, which must relate to the right of abode, may live, work and settle in the United Kingdom by permission and subject to such regulation and control of their entry into stay in and departure, as is imposed by this Act, as we've seen now by others. So there is a difference drawn.
Yes, but does it assist us in any way in understanding section, the meaning of, for the purposes, assuming you reject my...
Well, this may undermine your argument, actually, because you're pointing out that the rights that are confirmed are rights of residence, and the right to require a permit to reside
There's no requirement for a permit to reside.
No, but you've just taken us to the
And there's
legislation that entitles someone to apply for a residence permit.
So the right to reside under that.
I know. There's a difference drawn in the 1971 Act, is there not, between a right of abode and a right to work and settle?
Yes.
Well, hasn't your argument so far been predicated on the basis that a right to reside and settle equates to a right of abode?
My lady, our point simply on this is that these are national ways of regulating your right to live here. The source is national law. They are not for purposes of grant. They are not in order to give effect to rights or obligations afforded by EU law.
I understand that.
The EU law rights are adopted into English law by domestic legislation.
Through Section 2.2 or not directly, that can be directly relied on by Section 2.1. And our submission on that is that Parliament did not, I think I've made the submission, did not and cannot be intended in the 1971 Act and the 1981 Act to include that source.
No. So looking then at subsection 2, did they need to include that source? Because it distinguishes from a right of abode.
That is
It's a genuine question, Miss
well, I have
Seymour.
no,
I'm not
doubting. I'm not doubting
No.
it. I just want to give you a sensible answer. And the Section 1.2 effectively imposes a requirement of permission.
I'm sorry?
It imposes a requirement of permission. And what happened here was that that permission requirement was relied on by the United Kingdom for a significant period as the basis on which EU citizens were allowed to come in, and that was found to be unlawful. And as a consequence of that, we had the 1988 Act that took EU citizens out of the requirement for permission and put them in a separate category, i.e. exempted them from the requirement of permission.
To live, work and settle.
To live, work and settle.
Yes.
Now, as I understand it, my lady is saying to me, well, therefore, it was for the same purposes. Because it was just done through a different route. But we say no. We say what happened was Parliament took EU citizens exercising free movement rights out of the purview of the 71 Act in the 1988 Act, Section 7.1, and enacted through Section 2.2 gave effect to rights and obligations. And that was a very different purpose from the purpose of the 71 Act, which was to regulate permission. It was to give effect to a right which could be relied on, and in fact had to be relied on, existed without permission.
Depends on the level of abstraction of which you're looking at purpose, doesn't it?
Yes. Well, our essential argument is that purpose needs to be looked at in terms of how it was being viewed at the time of the 71 Act, 33, and the 81 Act, Section 50. And we say that it was plainly confined to purposes in dependent territories and the islands, etc. That's why it's there. It's not to cover anything vague that might relate to immigration. And it doesn't say for the purposes of the right to enter and remain, for example. Enter and remain. It says the purposes of 1970. It says the 1971 Act, which is our primary submission, or for purposes similar in dependent territories. Now we say what Parliament was doing, and indeed what the Home Office decided, was that immigration laws should not apply to EU citizens exercising free movement rights. Parliament, and indeed the Home Office, decided that where EU nationals were ordinarily resident and exercising free movement rights, children born to them should be accorded British nationality. So the purpose sorry, I realise that reason I'm going on a point that actually doesn't fit with what I was saying was that I am in my submissions I was going to take you to more of the EU provisions and we got diverted onto that. But I do, perhaps it is helpful for me to take the court to the EU, the underlying EU provisions, to show you what the purpose of those provisions was. And we can start with Regulation 161268, because this was, of course, well established by the time of the 1981 Act. And you find that at tab 17. If you just look at the preamble, you'll see that whereas freedom of movement of workers should be secured within the community by the end of the transitional period at latest, whereas the attainment of this objective, this is the first recital, entails the abolition of any discrimination based on nationality between workers of the member states as regards employment, remuneration and other conditions of work and employment, as well as the right of such workers to move freely within the community in order to pursue activities as employed persons, subject to limitations justified on grounds of public security, public policy, public security or public health. Then if you skip the next one and start with whereas freedom of movement constitutes a fundamental right of workers and their families, whereas mobility of labour within the community must be one of the means by which the worker is guaranteed the possibility of improving his living and working conditions and promoting his social advancement while helping to satisfy the requirements of the economies of member states, whereas the right of all workers in the member states to pursue the activity of their choice within the community should be affirmed. And then skipping the next one, whereas the right to freedom of movement, in order that it may be exercised by objective standards in freedom and dignity, requires that equality of treatment shall be ensured in fact and in law in respect of all matters related to the actual pursuit of activities, eligibility for housing, and also that obstacles to the mobility of workers shall be eliminated, in particular as regards the worker's right to be joined by his family relevant to settlement, and conditions for the integration of the family into the host country. So the objective behind all this is to ensure that individuals within the EU can move freely and settle freely. And if you go to the regulation, which is in the prior tab, which I may come back to, you see some of the provisions that we've seen implemented in the 1994 order. Section 6(1)(b), the resident permit must be valid for at least 5 years from the date of issue, be automatically renewable. And then the preamble is the first two whereases.
So you're taking us here to show us the purpose of
Yes.
the regulations.
Yes.
All right. So
And the reason for this in part is because this is the context in which the government, in enacting Section 50 and Section 7 of the 1988 Act, i.e. taking EU nationals out of immigration control, this is the context. The context is that there was a move towards integration of individuals, ability to move freely within the community with your family, in search of work, to be unemployed, to seek services, etc., etc. And the reason that that context is relevant is because one has to ask oneself, why would Parliament have decided that EU nationals who are ordinarily resident in the United Kingdom and who are exercising free movement rights should be able to give birth to a child who would be afforded British nationality. And so it's the context of enacting this legislation. And in our submission, the entirety of this legislation, which is in the bundle, shows that the context from very early on, and as Parliament understood, was that you were free as an EU national to move and settle. And the United Kingdom Parliament decided that as such, if you were ordinarily resident and you gave birth to a child, that child should be afforded UK citizenship. And just as an aside, I should mention that, of course, the prior position was that pretty much anybody who gave birth in the United Kingdom, their child became British. So we're talking about cutting down rights in any event. So what Parliament was asking itself was, should we say that EU nationals exercising free movement rights who are ordinarily resident here should not be entitled to have their children as British? And I say, by reference to this legislation, that the context was integration, the context was settlement, the context was that people should be able to move freely and settle in any state and should be subject to non-discrimination in any state.
well, you say that, but it wasn't settling freely because there were residence permits that had a specific validity date.
Well, I did say, perhaps we didn't go to the provision, the right to reside was never dependent on the issuing of a residence permit. So the right to reside
Right. So
and the right to move freely.
Yeah, but you took us, Miss Simon, particularly to Article 6. So why did you take us to Article 6, which is about residence permits?
Well, I took you to 6.1b.
Again, it's me, I'm sure, but
I took you
it
to
would be very helpful to me if you could make your submission and then take us to the relevant authorities or legislation, because I'm finding some difficulty in following you at times.
I took you to 6.1b to show you that you had a right under EU law to a residence permit that was automatically renewable.
Yeah, but you're saying that that's not dependent. Your argument is not dependent on
I think
that.
what happened may have happened because I was going to take you to that clause. I think we got diverted earlier when I was in the 1994 order. But I will take you to the provision that makes it clear that your right to reside was and never has been dependent on the issue of a permit for obvious reasons. The state is obliged to issue a permit, but if the state doesn't issue a permit, that in no way affects your right to reside.
Right. So the regulations are specific as to the validity.
No, not in that. It's in the legislation. It's in the legislation. We'll find it.
So I was saying, Miss Simon, that the regulation to which you directed our attention, Article 6, 1b, indicates a period of validity. So if you don't need the resident permit at all, why is there that specification?
Because in many states, in fact in the United Kingdom it's not the case, but in many states residence permits are required. But if you look, for example, at Article 4, you'll see Article 4.1. Member states shall grant the right of residence in their territory to the persons referred to in Article 1. Residence permit was not something that was common in the United Kingdom.
And go on to Article 4.2. As proof of the right of residence, a document entitled resident permit shall be issued.
Shall be issued, but in many states it was not issued, including the United Kingdom. And it was not determinative of your actual exercise of the right. So it's an obligation on the state.
So the context that you're providing is that so the context that you're providing, Ms. Seymour, is right of residence.
No, my lady, the context I'm providing by reference to those preambles, etc., was what the free movement rights involve. These are implementation, technical implementation treaty rights. I was going to take you through them, but the context is the preamble, which shows you what they're doing. And the purpose is that across the EU, people should be able to move, settle, bring their families, seek work, etc. And those are rights afforded by the treaty as implemented by these secondary provisions of EU law. Those rights exist, for example, the right to reside, irrespective of whether the state complies with the obligation to grant a residence permit for obvious reasons.
But you have to be a qualifying person.
Yes.
Right.
Now,
okay.
that's not in doubt. You've got to be a qualifying person. A qualifying person is an extremely wide definition, because if you are a worker, that includes, it's an autonomous EU concept. That includes, for example, someone seeking work. So if you're made unemployed, you do not cease to be a worker. Therefore, the definitional nature of a qualified person is extremely broad. There will be a point at time in
Do
which
we need to go there?
In my submission, no, because it is accepted.
So if we don't need to go there, shall we go on to something that we do need to go to?
Yes, although I would like to just no, that's actually not somewhere else. We'll find the exact provision, although I did take you to 4.1 of the 1994 order, the implementation, and that's at tab 9, page 49. So there is an entitlement to resign in the 1994 order, which implements that right that exists in EU law. I think one of the problems, my lady, is that I skipped over some of the provisions that I had been intending to take you to. And then
What did you direct us to in the 1994 order?
it's Regulation 4. So the UK implementation of the EU right to reside is provided by English law. A qualified person shall be entitled to reside. It's not dependent on a residence permit.
Miss Seymour, you told the court that you had 7 points to make. The last time I numbered one of them, it was number 3, which related to any lawful purposes.
Well, you're quite right, because I'm on the 4th.
Right. Will you just identify the 4th, please, because my lady is not alone in having some difficulty following.
No, I'm still on the third point. And the third point remains the point that purpose in section 2.2 is not in our submission the 1971 Act or purposes similar to. So that is the point that I'm making here. And my lady, I reiterate that that is secondary to our submission as to the meaning of purposes being essentially concerned with the islands and crown dependencies, which is our first point. Our fourth point, so just to sum up, we submit that the immigration laws meant the 1971 Act and any rules and SIs enacted pursuant to it, so the immigration laws, and legislation adopted for purposes similar to the Immigration Act in Jersey and Guernsey, or the dependent territories when extended. That's what we say it meant. And our fourth point is that this interpretation is supported by Parliament's enactment of Section 7 of the Immigration Act, which I've taken you to. It's at Authorities Bundle 8, and also the exclusion of the immigration rules, which is at Authorities Bundle tab 34. Paragraph 5, page 516. Save where expressly indicated, these rules do not apply to the EEA national family member of such a national who is entitled to enter or remain in the United Kingdom by virtue of the provisions of the EEA order. So what happened was that we had Section 7 of the 1988 Act took EU nationals, qualified nationals, out of the Immigration Act, and paragraph 5 took them out of the rules. Removing EU nationals exercising free movement rights from the 71 Act, we say constituted a recognition of the fact that it was inconsistent with EU law rights for legislation to require leave to enter and remain. And it was for that reason that Section 7 exempted EU nationals from the 1971 Act requirements in relation to leave to enter and remain. Parliament, we say, took EU nationals out of the Immigration Act. And provided an EU national was exercising the EU free movement right, he was not therefore covered, we say, by the immigration laws, namely the 1971 Act provisions relating to entering and remaining, nor by the immigration rules. For the purposes of understanding the British Nationality Act definition of settled, we say one must look to that parliamentary decision. Domestic restrictions in relation to leave to enter and remain under the 71 Act were removed, we say, by taking EU nationals out of its application. And as I've shown you, if an EU law right no longer existed, then the 1971 Act would reapply. I showed you that in Regulation 20 of the 1994 order. Now, our fifth point is that Parliament did not provide that this exemption from the application of the 71 Act was an exemption that could not be relied upon for the purposes of showing that one was settled under the British Nationality Act. And we say that had Parliament intended that, it would have provided for it. And that is exactly what it did, my ladies, my lord, in relation to other categories who were exempted from the same provisions of the 71 Act. I took you to section 50, subsection 3 of section 50, subsection 4 of the British Nationality Act, which refer to sections 8 of the 71 Act, so those categories. So can I take you straight to section 8, or do you want to return to 50, subsection 3 first? Perhaps sensible just to look back at subsection 50 subsection 3 and 4 of the British Nationality Act. Parliament specifically provides that if you're entitled to be exempted from the provisions of the 71 Act, you cannot rely on that exemption as a basis for claiming that you're settled if the exemption arises under section 8.3, 4b or c of the 71 Act. And you find the 71 Act in the 4th tab of the Authorities Public. You'll find the categories at page 23. So the relevant categories are 8.3, and they relate to a person so long as he is a member of a mission within the meaning of the Diplomatic Privileges Act, a person who is a member of the family and forms part of the household of such a member, or a person otherwise entitled to the like immunity from jurisdiction as conferred. So if you're a diplomat, you're exempted from the Immigration Act, but you can't rely on that to claim that you're settled. So even though you've been a diplomat here, if your child is born here, you cannot grant that child British nationality. And then 4b and c, we have being a member of a Commonwealth force or of a force raised under the law of any colony, protected or is undergoing or about to go training, etc. So a member of the armed forces or the Commonwealth forces or force of a colony. Or C, he is serving or posted for service in the United Kingdom as a member of a visiting force. So again, however long you were here, even if you could claim you were ordinarily resident, you could not claim you were settled as a result of that exemption. Now, other categories were not precluded from relying on the exemption to establish lack of restrictions under immigration laws to establish settled. So 8.4a, for example, was not excluded. So if you're a subject as a member of the Home Forces to service law. Now we say that that is precisely the position in relation to EU nationals, exempted under section 7.1 of the 1988 Act. There was no amendment to section 50 of the British Nationality Act or section 8, which wouldn't be section 8 because EU nationals have been taken out, but you would have expected to see that amendment to preclude EU nationals exercising free movement rights from their entitlement to rely on the exemption as a basis for arguing that they were settled. Now, the respondent's answer to this point is at footnote 16 of his skeleton, which is at Core Bundle 5, page 63. And he says, we don't need to go to it because I can tell you what he says. He says the correct comparable category to that of EU nationals exercising free movement rights is that provided in section 8.1. We say that that is not an analogous category. It is an individual who arrives at a place in the United Kingdom as a member of the crew, and then he may, without leave, enter the United Kingdom at that place and remain until the departure of the ship or aircraft on which he is required by his engagement to leave. So it's a clearly time-limited restriction.
Is there a distinction between these cases, express exemptions under Section 8, and the position of EU citizens under Section 7, that they are subject to a number of other pieces of legislation which deal with their entitlement to remain and work in United Kingdom?
But what we're asking ourselves at this point is whether, in the definition of settled, they are subject to a restriction under the 1971 Act. That's the question. We're going to deal with the second part of the question, which is for the period, in a moment. But the question is, were they subject to a restriction under the immigration laws?
Or similar.
Or similar, but subject to our...
Whereas none of these persons in Section 8 of the 1971 Act are even arguably subject to any other legislation in relation to their right to remain. They're simply exempted from the immigration provision. Whereas
there may well be separate provisions relating to them. They're exempted from the operation of this bit of the Act. There may well be separate legislation dealing with them. We can look into that.
well, the question is, isn't it, everyone's agreed, as I understand it, the 1971 Act does not restrict the rights of EU citizens. The question is the similar legislation, the similar law.
But that's what we're...
Yes. So if there in fact is similar law in relation to those exempted persons, then that might be relevant to this argument.
Except that we would have expected the 1971 Act, remember it's 1971 Act, to be amended specifically to refer, we say, to European Community law equivalent.
Well, that's the argument.
That's the argument. That's the argument.
And
that's how it was
rightly
interpreted.
say,
And important, it's not, I'm not coming from nowhere. This is how the Secretary of State interpreted her own legislation for 17 years. And that's not irrelevant. The normal, what one would have expected is to say, yes, the EU citizens, the EU nationals are taken out of the Immigration Act, but that exemption does not, cannot be relied on for the purpose of settled. The fact that that amendment was not made in our submission is relevant. So we say the intention of the 1988 Act was to take EEA nationals outside of the Immigration Act, outside of wherever that person had an enforceable EU right to enter or remain, and for that exemption to enable them to establish that they were settled, provided they could show ordinary residence. And that, as I've said, is precisely how the Secretary of State himself interpreted the legislation for more than 17 years. Accordingly, an EU national exercising free movement rights and ordinarily resident in the UK was settled under the British Nationality Act. And that is because he was not subject to restrictions under the 1971 Act, i.e. immigration laws, as to the period for which he could remain. And the judge misunderstood this point, or rather, he didn't misunderstand, he made an error in his analysis of this point. And you find that in paragraph 87 of his judgment.
2000 regulation.
Yes. So here, in this paragraph, he mistakenly appears to believe that EU nationals are taken out of the purview of the Immigration Act, immigration laws we say, by the 2000 regulations. So he ignores in this paragraph the crucial section, Section 7 of the 1988 Act, and Rule 5 of the 1994 immigration rules. And as soon as you look at it in terms of primary legislation, the reasoning in 87 collapses.
Is that your point 5?
That's my point 5. So my sixth point is that that interpretation is supported by authority. And if we can start with the Caporelli case, it's tab 27. And the judge deals with this case at paragraphs 54 to 64 of his judgment. We deal with it at paragraphs 37 to 39.
Just hang on a second, please. So it's tab 27 that you've taken us
Yes.
to.
I just want for your note to tell you where it's dealt with by the judge.
Yeah, I'm really pleased that you're going to. It's just that you're going so fast I can't note it. So tab 27 is the authority, and then you've directed us to the judgment at paragraph.
Judgment at paragraphs 54 to 64.
Thank you.
Which is core bundle, tab 8, page 80. And we deal with it at paragraphs 37 to 39 of our skeleton, which is core bundle 4, core bundle tab 4, page 35. Now, if we go to paragraph 2 of this judgment, we see the central question in the case. The central question of law which arises is whether the appellant is a British citizen. And then if you go to paragraph 18, you see the judge referring here to the IAT case of Gull, which he disagrees with at this point. Although Gull, the IAT, accepted that immigration laws encompasses the EU rules on free movement, I would question the correctness of this. Since 1971, via Section 33, the Immigration Act of that year, the definition of immigration laws has been, and there you see the same definition as in Section 50 of the British Nationality Act. I consider that the ordinary and natural meaning of these words does not encompass the EU rules on free movement. The definition makes no mention of the EU laws, primary or secondary. Furthermore, the 1971 Act predated the accession of the UK to the EU, and this definition was not amended subsequently. Notably, the definition was repeated when the 1981 Act was introduced, see Section 51. In my judgment, immigration laws are confined to laws made by the United Kingdom Parliament. If this phrase were designed to extend to any provisions of EU law, one would expect clear words to that effect. There are none. To complete this discrete analysis, paragraph 5 of the immigration rules makes clear that they have no application to EU citizens exercising treaty rights. He then, at paragraph 19, reaches what we say was an incorrect conclusion. He concludes that because EU citizens were not subject to any restrictions at the time under the immigration laws, they could not claim to be settled. And we find that a bizarre conclusion, but we say that his conclusion in paragraph 18 was correct. Our submission is that if you are not subject to any restrictions under the immigration laws, that is an indication that you are settled, according to the definition in section 50 of the British Nationality Act. And then in 20, in short, there is no merger of United Kingdom immigration laws with EU treaty free movement rights. The view expressed in Gall that the latter are immersed within the former is, in my estimation, misconceived. These are two quite distinct legal regimes in the context of under scrutiny, i.e. in exactly the same context as we're concerned with here. Now, the judge below rejected that submission, and we deal with his analysis of why his analysis was wrong at paragraph 49 of our skeleton. First, we say that the basis on which he distinguished Caporelli from this case was not legitimate. The question to be analysed was whether Parliament intended immigration laws as defined in section 33(1) of the 71 Act and 50 of the 81 Act to include EU rights and obligations. And that question is the same today as it was in 1981, 81. And therefore, Judge McCluskey's reason, Justice McCluskey's reason at paragraph 18 applies equally today or in 2000 or at any relevant time. The defendant had argued that Caporelli could be distinguished because it related to the position in 1986. And you find that recorded in Mr. Justice Eyre's judgment at paragraph 72. Just about 4 lines down, the defendant says that the decision is distinguishable because Ms. McCluskey J was dealing with the position as it had been in 1986. Accordingly, he was considering the position before the 1994 order and Section 7 of the 1988 Act had come into force, and before Regulation 14 of the 2000 regulations had been enacted. And the defendant says that those are laws made by or under the authority of the UK Parliament, and points to their existence as a material difference between the situation which McCluskey J was addressing and that which I have to consider. Now, in truth, my ladies, my lord, the legal position was no different. In 1986, the Secretary of State granted leave to remain through the immigration rules. That's explained in paragraph 29 of the judgment. So, in fact, the Secretary of State used the immigration rules to grant entry and leave to remain. And subsequently, EU nationals were exempted by the 1988 Act from leave to remain. The important point, however, in all this is that as at 1986, the basis for entitlement to enter and remain without leave derived from EU law, derived from the treaty, the 1968 regulation, for example, the treaty articles. And that position was no different in 2000. In effect, it was given effect through Section 2(1) of the European Communities Act, which is also parliamentary legislation. So the adoption of the 2000 regulations pursuant to the European Community Act does not help this court understand what Parliament meant in 1971 and 1981 when it referred to immigration laws. And we explain this more at paragraph 49 of our skeleton argument. I want to take you now to the second authority, which sheds less light than this one. Unfortunately, that was not in the bundle. It's a case called Akanthanya. It was referred to by the judge.
Why aren't these in the bundle?
I can only apologise. When I came to writing submissions for the court, I looked at it and I thought it would actually be quite helpful for you to see it. But there's always such a large delay between the application for permission and the final hearing.
Well, that gives everyone time to get their
Theory,
stock in order.
in
doesn't
theory,
it?
yes. At best, this is not in the way that Caporelli is precisely the same point. It's the view of the judge, Lord Justice Underhill.
Mr. Blundell, have you had these authorities in advance?
I had them this morning, my lady, and they were relied on at first instance, and I was in after so I can
Where would you like us to go to in Akasai?
Paragraph 20.
Thank
I can
you.
actually find my copy. Paragraph 20 and then paragraph 30. Paragraph 20. So, just to open, the judge rejected the relevance of Lord Justice Underhill's statement in Akasai. The rights deriving from EU law do not form part of the scheme of the Immigration Act. Now, this was a complex case that concerned the refusal of settled status to a mother who was Colombian, whose right to be in the United Kingdom derived from her right to care for children who were UK citizens. And this is known as a Zambrano right or a derivative right. It's an EU law right that follows from the court finding that states cannot take action that would have the effect of depriving EU citizens, in this case British citizens, of living in the EU, for example by deporting their mother, and thus necessarily resulting in those individuals having to leave as well. But the key point is at paragraphs 20 and 30.
Paragraph 20, which part of it?
So limited, just at the bottom, H, limited leave may be, and generally is subject to conditions, which may include restrictions on the beneficiary's right to work or access to social security, ILR, etc. While the UK was a member of the EU, this scheme had no application to EU nationals or those with rights under EU law deriving from the rights of such nationals, since they were, broadly speaking, entitled to live and work here without any requirement, i.e. the reference to Section 7. So none of the provisions relating to immigration control related to these third country nationals enforcing EU law rights. And then if you go to 30, you find both the 2016 regulations and the 2006 regulations were, in relevant aspects, made under Section 2.2 of the European Community Act. Since the rights recognised by them derive from EU law, they do not form part of the scheme under the Immigration Act. See paragraph 20 above. Specifically, a derivative right to reside does not constitute a form of leave to remain. One consequence of this is it does not provide a route to settlement. That is a route to settlement through the UK domestic immigration law right route. Now, we say that Mr. Justice Eyre wrongly dismissed the relevance of Mr. Justice Underhill's statement. Whilst not concerned with the definition...
Can you tell us where in his judgment he does so?
I think it was 40... Did I say 40... 66 of Code Britain, tab 8, paragraph 66, which is on page 83.
Well, at paragraph 66 of his judgment, the judge merely refers to paragraph 30, as you've just taken us to. So where does he say it doesn't assist him? Oh, here we go, 67.
67. So he says it doesn't take you further. It just says it doesn't help you. And in that sense, we submit it. It supports the position in Caporelli, which was explicit, that Immigration Act 1971, immigration laws means Immigration Act 1971. It doesn't mean EU laws enacted pursuant to Section 2.2 of the European Communities Act.
But the judge is right, wasn't he? It's not addressing the same question.
No, it simply says it's a different, our submission, it's a different package. What did language he used?
Well, he seems to agree with you, saying that it's not on point. It doesn't assist him with the questions he has to address. Isn't that your point?
We say it assists us with saying that it is a separate regime, and therefore it is not in line with the judge in Caporelli. They cannot be viewed as part and parcel of the same set of immigration laws as defined in 33(1) of 71 Act and 50 of the 88 Act. 81 Act.
Well, what Lord Justice Underhill said in paragraph 30 is that since they do not form part of the scheme under the 1971 Act, well, I thought it was uncontroversial.
Yes.
And the question we're considering, is whether or not other provisions are purposes similar to them.
But if that's how you interpret purposes similar to, yes.
That's the question. So I must admit, I rather agree with the judge.
Well, then maybe
I don't think it answers the question at all.
My juniors made the right decision in not referring to it in our Court of Appeals category. In my submission, it does assist in showing that it's a separate scheme and it's not for the same purposes. If you interpret purposes as to mean what actual purposes does the Act entail, which we say is not what purposes means then. So our seventh and final point is that if the judge was right that the 2000 regulations are laws for the purposes similar to the 71 Act within the meaning of Section 50 of the British Nationality Act, then Regulation 8 of the 2000 regulations was entirely pointless. You find, well, I've shown you that regulation right at the beginning of my submissions this morning. The point here is that if immigration laws, in fact, meant all and any legislation adopted pursuant to Section 2.2 and all and any rights and obligations that could be relied on under Section 2.1 of the European Communities Act, then there was no need for Regulation 8. Because that would have been the case without Regulation 8. Put another way, Regulation 8 proceeds on the basis that it's necessary to define in regulations those that are not subject to restrictions under immigration laws for the purposes of the British Nationality Act. If, however, Parliament had intended by Section 50 of the British Nationality Act to preclude anyone who could not establish an EU right to permanent residence, then the definition of settled, then permanent residence from the definition, then it would have been not been necessary for Regulation 8 to be adopted. That is an important point, because State submissions, you determine settled by reference to the question of whether EU law accords you a right to permanent residence. That is its submission before this court. And unless, as an EU national, you could show that you had a right to permanent residence under EU law, you could not be settled within the meaning of the British Nationality Act. It follows that if that submission is correct, then Regulation 8 was never needed. Regulation 8 of 2000 regulations. Because what Regulation 8 does is specifically define when you are or are not able to claim that you are not subject to restrictions under the immigration laws. Go to regulation. Tab 11. With respect, this provision is equivalent to what I have submitted you would have expected to have seen by way of removal of entitlement to rely on the exemption from the Immigration Act in sections 50, subsection 3 and 4 of the British Nationality Act. But what matters before this court, my ladies, my lord, is that when Parliament enacted the British Nationality Act, and then subsequently the 1988 Act in Section 7, it did not amend Sections 53 and Sections 50, subsection 4, in such a way as to insert a provision equivalent to Regulation 8 of the 2000 regulations. So to conclude, up until the 2000 regulations, the Secretary of State treated EU citizens who were exercising free movement rights as not being subject under the immigration laws, as defined in the British Nationality Act, to restrictions. In truth, they were exempt from the immigration laws, the 1971 Act, and accordingly, provided they satisfied the test of being ordinarily resident in the UK, they were treated as settled. And that was altogether unsurprising, bearing in mind, one, the fact that the British Nationality Act reduced rights. It was the removal of rights, the right of jus soli, i.e. the right to British nationality if you're born here, and a decision as to where that line would be drawn. That's the first point. And the second point is the point I was making in a rather confused way in relation to the actual regulations, which is that the overall context, the overall EU context was, should we grant EU citizens ordinarily resident here who are exercising free movement rights, should we allow their children British nationality? And in our submission, it was plain that that was Parliament's decision. And that decision was borne out by how the Secretary of State applied his own legislation for 17 years. And that might be a good moment to stop. I only have the second point, which is the question as to what period means, period for which you may remain in Section 50, subsection 2.
And how long do you think you might be on that one?
Well, that should be, I hope, a little bit shorter. But it may be that I will need an hour and a half. You may push further than. You may want me to go more quickly.
Well,
Well, it said you have a court of appeal authority against you,
Yes,
binding authority.
yes.
Presumably that's going to take a little while.
That takes a little while. And I'm going to show you a Bermuda Supreme Court authority, which is to contrary effect.
and that hopefully is in the authorities bundle.
Yes, it is.
All right. 2 o'clock, please.